The 19-year-old defendant wasn't supposed to know the law better than the prosecutor. He definitely wasn't supposed to outsmart the judge. But when he started citing case law from memory, the entire courtroom realized they were dealing with someone extraordinary.
Don't forget to subscribe, leave a like, and a comment before we start to learn more about what happened.
The Cook County Courthouse buzzed with its usual morning activity as lawyers hurried between courtrooms, defendants waited nervously in hallways, and court reporters prepared for another day of legal proceedings. In courtroom 304, Judge William Harrison reviewed his docket with the wary expression of someone who had presided over thousands of cases during his 25-year career. Judge Harrison was known throughout the Chicago legal community as a no-nonsense jurist who ran his courtroom with strict efficiency. At 62, he had seen every type of case and every kind of defendant. He prided himself on being able to assess a case within minutes of reviewing the charges and rarely encountered surprises that challenged his expectations. Today's morning docket included the usual array of minor offenses, traffic violations, petty theft, disorderly conduct, and a handful of more serious charges. One case, however, stood out not because of its severity, but because of an unusual notation in the file. Defendant requests to represent himself. Marcus Williams, 19 years old, sat in the gallery waiting for his case to be called. He wore a simple button-down shirt, dark pants, and carried a worn leather briefcase that had belonged to his grandfather. To most observers, he looked like any other young defendant facing charges in the criminal justice system. What they couldn't see was the extraordinary mind behind Marcus's calm exterior. Since the age of 12, he had been studying law with an intensity that most people reserved for their professional careers. He had read every major Supreme Court decision, memorized landmark cases, and understood legal procedure better than many practicing attorneys. Marcus's interest in law began when his older brother had been wrongfully convicted of a crime he didn't commit. The family couldn't afford an adequate legal defense, and Marcus watched helplessly as his brother was sentenced to 5 years in prison. That experience ignited a passion for justice that would define Marcus's teenage years. While his classmates played video games and attended parties, Marcus spent his evenings in the public library, reading law books and court transcripts. He taught himself legal research, studied constitutional law, and developed an encyclopedic knowledge of criminal procedure. By age 18, he had accumulated more practical legal knowledge than many first-year law students. Now, facing charges of his own, possession of marijuana and resisting arrest, charges he vehemently denied, Marcus had made the decision to represent himself. He couldn't afford a private attorney, and his experience with public defenders had convinced him that he could provide a more effective defense than an overworked lawyer with dozens of other cases. "The people of Illinois versus Marcus Williams," the bailiff announced. Marcus stood and walked to the defendant's table, setting his briefcase down with quiet confidence. The prosecutor, Assistant District Attorney Jennifer Ross, looked up from her notes with mild curiosity. Ross was in her early 30s, with 5 years of experience prosecuting minor criminal cases. She had reviewed Marcus's file and expected a routine plea bargain or quick guilty verdict. Judge Harrison peered over his glasses at Marcus. "Mr. Williams, I see here that you've waived your right to counsel and intend to represent yourself. Is that correct?" "Yes, Your Honor," Marcus replied, his voice clear and respectful. "Young man," Judge Harrison said, his tone carrying a hint of condescension, "I have to advise you that representing yourself in a criminal matter is generally not wise. The law is complex, and you're facing charges that could result in significant penalties." Marcus nodded politely. "I understand the risks, Your Honor, and I appreciate the court's concern. However, I'm confident in my ability to provide an adequate defense." Judge Harrison exchanged a glance with the court reporter, a look that suggested he'd seen this overconfidence before. Very well. Ms. Ross, please proceed with your opening statement. Prosecutor Ross stood and addressed the court with practiced efficiency. Your Honor, this is a straightforward case. On the evening of March 15th, Chicago police officers Martinez and Johnson observed the defendant acting suspiciously in Lincoln Park. When they approached to investigate, they discovered marijuana in the defendant's possession. When the officers attempted to make an arrest, the defendant resisted, requiring the use of restraints. Ross continued, "The state will present testimony from both officers confirming these facts, along with physical evidence recovered at the scene. We believe the evidence clearly establishes the defendant's guilt on both charges." Judge Harrison nodded and turned to Marcus. "Mr. Williams, do you wish to make an opening statement?" Marcus stood, and for the first time his demeanor shifted. The nervous energy that had surrounded him was replaced by a calm confidence that seemed to fill the courtroom. "Thank you, Your Honor," Marcus began. "The defense will show that this case represents a fundamental violation of my client's, that is, my Fourth Amendment rights under the United States Constitution." Judge Harrison's eyebrows raised slightly at the formal legal language, but he gestured for Marcus to continue. "The defense will demonstrate that the initial contact with police lacked reasonable suspicion as required under Terry v. Ohio, 392 U.S. 1, 1968. Furthermore, we will show that the subsequent search exceeded the scope permitted under the Supreme Court's ruling in Minnesota v. Dickerson, 508 U.S. 366, 1993. Prosecutor Ross looked up from her notes, surprised by Marcus's precise citation of case law. Judge Harrison leaned forward, his attention now fully focused on the young defendant. Marcus continued, "The defense will also establish that what the prosecution characterizes as resistance was actually my lawful response to an unlawful arrest, as established in the precedent set by Bad Elk v. United States, 177 U.S. 529, 1900, which held that citizens have the right to resist unlawful arrest, even to the point of taking the life of the officer if necessary." The courtroom fell silent. Even the court reporter paused in her typing, looking up at Marcus with amazement. It was unprecedented for a 19-year-old defendant to cite century-old Supreme Court precedent from memory, let alone do so with perfect accuracy. Judge Harrison cleared his throat. "Mr. Williams, did you just cite Bad Elk versus United States from memory?" "Yes, Your Honor. The specific holding was that, where the officer is killed in the course of the disorder, which naturally accompanies an attempted arrest that is resisted, the law looks with very different eyes upon the transaction, when the officer had the right to make the arrest from what it does, if the officer had no such right." Judge Harrison stared at Marcus for a long moment. "Proceed, Mr. Williams." "The defense will show that the officer's testimony contains material inconsistencies that undermine their credibility under the standard established in Brady v. Maryland, 373 U.S. 83, 1963. We will also demonstrate that the evidence was obtained in violation of the exclusionary rule as defined in Mapp v. Ohio, 367 U.S. 643, 1961. Prosecutor Ross was now frantically flipping through her files, clearly unprepared for the level of legal sophistication Marcus was displaying. Judge Harrison had abandoned any pretense of routine case management and was listening with the attention he typically reserved for complex appellate arguments. "Your Honor," Marcus continued, "we request that all evidence obtained as a result of the unlawful stop and search be suppressed under the fruit of the poisonous tree doctrine established in Silverthorne Lumber, Covey, United States, 251 U.S. 385, 1920. Judge Harrison called for a brief recess, during which he consulted his legal clerk to verify the accuracy of Marcus's citations. Every case reference was correct, every legal principle properly applied. When court reconvened, the judge's demeanor toward Marcus had completely changed. "The court will hear testimony from the arresting officers," Judge Harrison announced. Officer Martinez took the stand first, recounting his version of events with routine police testimony. Marcus listened carefully, taking detailed notes and preparing his cross-examination. When it was time for cross-examination, Marcus approached the witness stand with the confidence of a seasoned trial lawyer. "Officer Martinez," Marcus began, "you testified that you observed me acting suspiciously. Can you define for the court what constitutes suspicious behavior?" "Well, you were walking slowly, looking around, checking your phone frequently," Martinez replied. "I see. And in your training and experience, is walking slowly, looking around, and checking a phone behavior that would justify reasonable suspicion of criminal activity under the standards set forth in Terry v's Ohio?" Martinez hesitated. It seemed suspicious in the context. "Officer Martinez, are you familiar with the reasonable suspicion standard as defined by the Supreme Court?" Prosecutor Ross objected, arguing that the question was beyond the scope of the officer's expertise. Judge Harrison, however, was curious to see where Marcus was heading and overruled the objection. "The Supreme Court has held that reasonable suspicion requires specific and articulable facts that, taken together with rational inferences from those facts, would lead a reasonable officer to believe that criminal activity is afoot. Can you articulate specific facts that would lead a reasonable officer to suspect criminal activity?" Martinez looked uncomfortable. "Like I said, your behavior seemed suspicious." "Officer Martinez, would you agree that walking slowly, looking around, and checking a phone are activities that thousands of people engage in every day without committing crimes?" "I suppose so." Marcus continued his cross-examination with surgical precision, exposing inconsistencies in the officer's testimony and demonstrating that the initial stop lacked the constitutional requirements for lawful police contact. When Officer Johnson took the stand, Marcus employed similar tactics, revealing contradictions between the two officers' accounts and highlighting the lack of specific, articulable facts justifying their intervention. During his closing argument, Marcus delivered a legal analysis that would have impressed law school professors. "Your Honor," Marcus concluded, "the evidence clearly shows that this stop violated my Fourth Amendment rights. The officers lacked reasonable suspicion for the initial contact, the search exceeded constitutional bounds, and the arrest was therefore unlawful. Under the exclusionary rule, all evidence obtained as a result of this constitutional violation must be suppressed." Judge Harrison had presided over thousands of cases, but he had never witnessed a self-represented defendant demonstrate such sophisticated legal knowledge. Marcus hadn't just memorized case names. He understood the constitutional principles underlying each decision and applied them with precision. After a brief deliberation, Judge Harrison returned with his ruling. "In 30 years on the bench," Judge Harrison began, "I have rarely seen such a thorough and competent legal analysis from any attorney, let alone a 19-year-old defendant representing himself." The courtroom was completely silent. "The court finds that the defendant's constitutional analysis is correct. The initial stop lacked reasonable suspicion under Terry v's Ohio. The search exceeded constitutional parameters, and the arrest was therefore unlawful. All evidence obtained as a result of the unconstitutional stop is hereby suppressed." Judge Harrison paused, looking directly at Marcus. "Without this evidence, the prosecution cannot meet its burden of proof. The charges against Mr. Williams are hereby dismissed." The courtroom erupted in whispers and murmurs. Prosecutor Ross sat in stunned silence while Marcus simply nodded respectfully to the judge. "Mr. Williams," Judge Harrison said, "might I ask where you learned law?" Marcus stood. "Self-taught, Your Honor. I've been studying since I was 12 years old." "And what are your plans for the future?" "I start at Northwestern University Law School in the fall, Your Honor. Full scholarship." Judge Harrison smiled for the first time during the proceedings. "Mr. Williams, the legal profession will be fortunate to have you. This court is adjourned." As Marcus packed his briefcase and prepared to leave, several attorneys who had been observing the proceedings approached him with business cards and offers of internships. News of the case would spread throughout the Chicago legal community within hours. Word of Marcus's courtroom victory reached Northwestern Law School the same day. The dean personally called to congratulate him and offer additional scholarship support. Local newspapers picked up the story of the teenager who had outlawyered seasoned prosecutors and impressed a veteran judge. Marcus's success in court opened doors he had never imagined. Law firms offered him summer internships, legal advocacy groups invited him to speak at conferences, and civil rights organizations sought his involvement in important cases. Judge Harrison would later tell colleagues that Marcus Williams represented everything the legal profession should aspire to: thorough preparation, intellectual honesty, and an unwavering commitment to constitutional principles. 3 years later, Marcus graduated from Northwestern Law School as valedictorian. He went on to become a prominent civil rights attorney, specializing in police misconduct cases and constitutional law. He established a legal clinic providing free representation to defendants who couldn't afford adequate counsel, the same situation that had originally inspired his legal studies. Marcus never forgot the lesson his courtroom victory had taught him, that knowledge, preparation, and courage could overcome any prejudice or assumption. Age, race, and economic status didn't determine someone's worth or capability. Excellence did. And Judge Harrison, he became one of Marcus's strongest supporters, often citing their first courtroom encounter as a reminder that justice could come from the most unexpected sources, and that wisdom didn't always wear expensive suits or carry impressive credentials. Sometimes it wore a simple button-down shirt and carried a grandfather's old briefcase filled with nothing but knowledge, determination, and an unshakable belief in the power of truth.